You're driving home from the shore on a Sunday night after a long weekend when another driver is not paying attention, speeding, texting over the legal limit, slams into you, causing you injuries. Are you entitled to a bigger recovery against that driver than you would be against a driver who just simply wasn't paying attention? We take a look in this Legal Mythbusters. So if you were injured in this accident, what you would be bringing is called a civil claim against the other driver and their insurance company for your injuries. But we often get asked this question a lot. The person was speeding, the person was texting, the person was drunk. What does that mean for my damages? Well, the short answer is people can only be 100% at fault. So if someone wasn't paying attention and ran a red light, or they were on their cell phone and ran a red light, they still can only be 100% at fault. So we have to look at what are your injuries and how bad are your damages, meaning not only your injuries and how they're going to affect you now, but into the future. What are your medical bills, your lost wages, the need for further medical treatment? All of those factors are considered when evaluating your claim for damages. When you bring a civil claim, what you are doing is seeking damages. You are seeking damages against that other driver and their insurance company for your injuries, your pain, your suffering, the impact it's had on your life, your medical treatment, your future medical treatment, your lost wages, maybe your inability to earn going forward. All of those factors come into play when we're evaluating the damages. But do the actual circumstances of the accident change what you're entitled to? Well, the short answer is no, because someone can only be 100% at fault. They can't be 110% at fault or 150% at fault. So although the short answer was no, there's still two other areas of damages which you may be able to seek because of the facts of the case we mentioned earlier. First is what's called punitive damages. The damages we spoke about earlier are what are known as compensatory, meaning they are meant to compensate you for your injuries and everything that you've been through. Punitive damages are what they sound like. They're meant to punish the defendant. A jury in certain states can punish the defendant by awarding you damages for how egregious the actions were of the defendant. But the facts have to be bad. Usually the defendant's conduct has to be a willful and wanton disregard for the safety of others. It's not merely negligence, it's gross negligence or recklessness. And then the jury can award punitive damages. But there's another avenue that you could seek damages when the facts of the case are similar to the ones we did earlier, when the person is over the legal limit. If they were at a bar or a restaurant and they were overserved alcohol and that contributed to the accident, you may also have a claim against that bar or restaurant for your injuries. Most states have laws which are called dram shop laws. Bars and restaurants are not permitted to overserve visibly intoxicated individuals. So you would have a claim against the bar. However, your damages are what they are. So if it was determined that you had $100,000 worth of damages, you're not going to get $100,000 from the defendant driver and then also $100,000 from the bar. They would share in the responsibility. They would share in the negligence. And that would be one of the questions for the jury. Again, there's only 100% negligence to go around. So the jury could determine, we feel the defendant drunk driver was 50% negligent, and we think the bar that overserved them was 50% negligent. In that situation, if you were awarded $100,000, you'd get $50,000 from the driver, $50,000 from the bar, 50-50. So that's why the short answer here is no. You're not entitled to a bigger amount of damages because of the facts of how the accident occurred. But we talked about why that may come into play with human nature and the jury, with a little caveat too of punitive damages. Be sure to like and follow for more Legal Mythbusters.